Let's start with the concept of social justice and equality. Though both are very related terms, but yes, we are going to look into what is the meaning of social justice and in its context with reference to equality and how Indian Constitution has dealt with the same. So let's quickly start the presentation. So meaning and definition of social justice in the reference of equality. Equality means law treats everyone equally and does not favor anyone because either he doesn't belong to the advantage of the society. And there's another concept related to equality, which is the concept of proportional equality. State needs to take affirmative action in favor of the disadvantaged section of the society. However, the same needs to be within the framework of liberal democracy. Justice basically one formal justice, which is everyone needs to be treated equally. Justice is also equality is also related to the concept that the law, that is the parliament, within the framework of democracy needs to ensure protection to the disadvantaged section of the society. So it was held in the case of Nagaraj versus Union of India. Supreme Court held that social justice is one of the subdivisions of the concept of state. It is concerned with the distribution of benefits and burdens throughout a society as it results from social institutions, property system, etc. The concept of social justice is not limited to directive principles only. There can be no justice without equality. It is Article 14 which guarantees fundamental right to equality before the law on all persons. So, justice is possible only when all the people are treated equally, which is a fundamental right under Article 14 of the Constitution. Equality before law is the result of rule of law. So, what do we understand by rule of law? Rule of law means the principle of legality, which refers to a government based on the principle of law and not of men, in the sense the concept of rule of law is opposed to arbitrary power. Rule of law is one of the basic principles of Indian Constitution, also enriched in US Constitution and Indian Constitution. The entire basis of administrative law is the concept of rule of law. So rule of law basically means principle of legality by the government. Whatever the government makes needs to be through a majority. Whatever the government makes needs to be for the welfare of the people, and so on. Moving ahead, Dicey's concept of rule of law. Dicey attributed the following three meanings to the doctrine: 1. Supremacy of the rule of law; 2. Equality before law; 3. Predominance of legal spirit. Let's take up these concepts one by one. Supremacy of the rule of law. Dicey stated that rule of law means absolute supremacy of regular law as opposed to arbitrary powers of certain people. It excludes the existence of arbitrariness of prerogative power or even discretionary authority on the part of government. So, what it stated is rule of law will always prevail. Whatever is the decision of the majority, whatever is the decision by the appointed members, whatever is the decision by the maximum within the framework of constitution is the rule of law. Second, equality before law and social justice. Explaining the second postulate of the doctrine of rule of law, Dicey states there must be equality before the law or equal subjection of all laws to the ordinary rule of land by ordinary courts. It means while rendering justice, all should be treated equally on equal footing. This is what we mean by equality before law and social justice. Third, predominance of legal spirit. Explaining the third postulate, Dicey states the general principle of constitution are a result of judicial decision of the court. Those rights are the result of judicial decision in concrete ways which have arisen between this party. In this way, rule of law postulates judicial supremacy. So, whatever the judiciary has decided becomes the rule of the law. It may be pertaining to a particular dispute, it may be a dispute between two or more parties, but there is always predominance of legal spirit. With time, the concept of rule of law has changed. So, rule of law under Indian Constitution simply states Constitution is supreme. The preamble clearly lays down the principle of rule of law when it uses the words like social, economic, and political justice, equality of states, and opportunity and fraternity, dignity of individuals, all the fundamental rights, fundamental guarantees under Article 32 and 226, all ensure proper rule of law is followed in India. Law, including ordinance, bylaws, notification, customs, or usages having force of law, must conform to the constitutional provisions. Where they do not conform, they would be declared void and within the purview of Indian Constitution. In the famous case of Indira Nehru versus Raj Narayan, the Indian Constitution embodies the modern concept rule of law by virtue of the following features: 1. Supremacy of Constitution; 2. Constitutional requirement of equality; 3. Constitutional guarantee and judicial enforcement of rights; 4. Rule of law as a legal concept; 5. Rule of law as a basic structure; 6. Elimination of arbitrariness and discretion; 7. National policy of reservation for backward classes; 8. Pers- persuasiveness of the concept of rule of law. So it was in this case when rule of law is guaranteed and the Indian Constitution was expressly laid down. The new horizons of rule of law. The recent expansion of rule of law in every field of administrative function has been assigned. It is a place of special significance in Indian administrative law vis-a-vis operation of administrative power. Free legal aid to the poor, speedy trial in criminal cases are all within the ambit of new horizons of rule of law. Administrative accountancy, civil services accountancy, all of these ensure proper protection and protection of rule of law within the country. The doctrine of equality. The goal of equality of status and opportunity is envisaged under Article 14 to 18 of the Constitution. I think we are pretty clear with Article 14 lays down two principles: equality before law or equal protection of law. Equality before law is illustrated from 15 to 18 in part 4. Apart from this, Article 38, 39, 39A, 41 and 46 speak about the concept of equality. Among others, the concept of equality before law contemplates minimizing inequalities of income, facilities, opportunities to all, securing adequate means of livelihood to its citizens, promotes special care of educational and economic interest of the weaker sections, particularly the scheduled caste and scheduled tribe, protect them from social injustice and all forms of exploitation. So this is how equality is ensured within the purview of Indian Constitution. So as we have already discussed, liberty, equality, and fraternity are the three principles of social justice. The principle of equality before law and equal protection of law necessitate the socio-economic inequalities and disabilities need to be redressed, which is guaranteed under Article 15 to 17 of the Constitution. So that's about it. In case of any doubt, do get back to me. My email ID is Ratna, RATHNA, Malhotra, MALHOTRA, @gmail.com. Thank you for your time and do take care of yourself and your family and have a nice time at your home. Thank you so much for your time.